All right, so let's begin the program. First of all, I want to thank those of you who've joined us and given up your portion of your Friday morning. We're very pleased to have you here. Today we're going to talk about patent term adjustment, but in particular we're focused on the doctrine of obviousness double patenting and its interplay with patent term adjustment. I am Vincent Shire. I am a partner at the Oblon firm and have been working in the patent industry for over 20 years. And most of my work has focused primarily on patent prosecution and portfolio development, helping small and emerging companies align their intellectual property interests with their future growth. As well as done some post-grant work and involved in a little bit of litigation. And I'll let my colleague, Dick Kelly, introduce himself as well.
Thank you, Vince. I've been in the business about twice as long as Vince has, starting as an examiner and then transitioning to private practice with Oblon. And my practice is today primarily counseling and patent development in the life sciences area, although in the past I have done litigation, interferences, and IPRs. And Vince, the floor is yours.
All right. So first of all, I think it's important to understand that in the United States, after the Uruguay Round Agreements Act, we've moved to a patent term that's 20 years from earliest effective U.S. filing date. And that was a change from the pre-URAA, which was 17 years from the patent grant. But along with the modification of the patent term, also was instituted a scheme that allowed patentees to recoup some of the time lost due to examination. And this was in the form of patent term adjustment under Section 154, which is the very same section of statute that defines the 20-year patent term. And so the patent term by statute in the United States is actually 20 years from earliest effective filing date, plus the statutory modification of patent term adjustment. But the U.S. Patent Code also recognizes a second form of patent extension, which is a little bit different. And Dick, can you explain to us what that second extension is?
Sure. The term patent term extension is really a bit of a misnomer because it implies that the whole patent term is extended, when in fact only a portion of the patent term is extended, and that's the portion that covers the indication that was approved by the FDA for the drug or the medical device for that matter. It does not extend the patent generally. So if someone wants to use the patent for some other purposes, once the patent's expired, they're free to do so. Also, if the indication, the approved indication, is not approved until after the patent has expired, that approved indication is not covered in that extended term. Back to you, Vince.
Thanks, Dick. So looking a little bit closer at patent term adjustment, really the origin and the intent of patent term adjustment was to compensate the diligent patent applicant for delays that were caused during examination by the USPTO. And this really was in recognition of the fact that the Patent Office has long had increasing backlogs, has experienced increasing delays at times. And so there was great concern that moving from a 17-year from issuance to a 20-year from effective filing date could lead to a loss of effective patent term to the patent owner. And so patent term adjustment was the scheme that was introduced to compensate for that. It's gone through a couple of iterations, which have added additional types of delays. But in general, the kind of the concept is that for each day of PTO delay, which would fall into several different types of categories, an additional day of patent term would be added to that 20-year from effective filing date, offset by certain delays by the patent applicant. Well, patent term adjustment rules are what drive the calculation. The statute gives broad instruction, but it was largely left to the director to set forth rules as to how the reductions as well as the positive adjustments would be calculated. Largely, the patent term adjustment rules were not brought under significant scrutiny during the first 15 years that they existed, largely because most patents that were in force were not concerned with patent term adjustment at that time. And so that changed with the Wyeth v. Kappos case in the late 2000s. In the Wyeth v. Kappos, the Patent Office was asked to look at a rule of how the Patent Office was treating double counting of days for purposes of what we call the A and the B delay. And the Federal Circuit found that the Patent Office was wrong. They disagreed with how they were calculating it. And since Wyeth, it touched off a number of different types of challenges for against the U.S. Patent Office's rules for calculating the patent term adjustment. Many times, in fact, more often than not, the courts find that the Patent Office was wrong, and the Patent Office has to change the rules and the calculation and the algorithm. But really, the industry that's driven these challenges has been the pharmaceutical industry. And perhaps, Dick, you can explain, you work very closely with the pharmaceutical industry. Can you explain why that might be, why we would see this coming from the pharmaceutical industry?
Well, I think as you can see on the slide, the top five drugs last year sold from a low of 10.7 billion to a high of 19.8 billion. And if you do the math, you'll see that the 19.8 billion works out to something like $50 million a day. So every day at the end is very, very valuable. And the sale of drugs requires a ramp up. You have to go out and educate doctors about them and get them to write the prescriptions so that you're probably not getting to the maximum selling for several years, and you're amortizing over the time you're selling your research costs, whatever you're required for new equipment to manufacture the drugs. And by the end, towards the end of the life of the drug, those costs are all gone. You've already paid them off. So you're really talking about very high profit margins, which can be used to support new drug development. Because, you know, AbbVie is going out and doing things to replace Humira, which I believe will go not generic, but biosimilars in a year or two in the United States. It's already gone there in other countries. So this is very valuable and very important. And the other thing is the PTE was part of the grand bargain for the Wax-Hatchman Act, which allowed the generics to begin their preparations prior to the expiration of the patent under 271E1. So this is why the pharmaceutical industry is really focused in on it. The other thing is, if you look at electronics, the electronic devices in some cases are obsolete even before the patent issues because of the change being so rapid. Drugs are a completely different game. Vince?
Thanks, Dick. So as I said at the beginning, we're going to discuss the interplay with obviousness double patenting. So I think first it's important here to understand what double patenting really is in the U.S. And the doctrine of double patenting is an attempt to prevent unjustified extension of the patent exclusivity period beyond the term of a patent. And this was really to serve a public policy that promoted the ability of the public to use the inventions that are claimed upon the expiration of the patent. But it was not just the subject matter that expressly covered by the initial patent. It also is what would be considered obvious modifications or variants, thus the obviousness component of the double patenting. Prior to the Uruguay-Iran Agreement Act, double patenting was mostly found to result when the right to exclude was granted in the first patent was unjustly extended by the grant of a later issued patent. That worked under the pre-URAA, where the scheme had the patent term measured as 17 years from the grant of the patent. So it was very easy to understand the impact of the later issued patent on the effective term of the claims and obvious variants. But the question that really was posed after that is, well, what happens to post-URAA cases? And so one of the mechanisms that came into play in the 1950s was as a way for a patent owner to still be able to cover the full scope they were entitled to, but also to avoid invalidity on the basis of double patenting, was the creation of the terminal disclaimer that allowed a patentee to disclaim any portion of the second patent over the portion that would extend beyond the expiration of the first patent. In the second component of the terminal disclaimer was a requirement that the two patents that are subject to the disclaimer remain commonly owned. And if that common ownership is lost, then the patent in which the disclaimer was filed would be invalid. And so just to take a quick look at a very simple situation of how terminal disclaimers would impact patent term as well as patent term adjustment, we just take a very simple case, straightforward 20 years from issue, and a second case, case B, where we have a later granted patent that has some patent term adjustment. If a terminal disclaimer is filed in B over A, the result would be that you would lose the entire term dating back to the expiration of patent A, which would include the loss of your patent term adjustment. And the rationale behind this is that it's squarely within the scope of the section of the U.S. Code related to disclaimers that you disclaim all of the period of 154 that extends beyond. And 154, as we said earlier, includes PTA. So if we can look at another situation where we have a slightly different example where both patents have a little bit of patent term adjustment, and again, we have a terminal disclaimer in B over A, the end result is that the term is lost dating back to the statutory expiration of A, which is 20 years plus patent term adjustment. The next example is looking at the impact of filing in the opposite direction. If we have two patents and we file a disclaimer in the earlier expiring patent, which in this case is A, and you're filing the terminal disclaimer over B, what is the impact? The impact is that it doesn't impact the term. The terminal disclaimer is unidirectional. What that means is your filing over B does not work in reverse to effectively shorten the term of B over A. A separate disclaimer would need to be filed in B. So in this instance, since we're filing the disclaimer in A over B, and that was already set to expire earlier, there's no impact on the expiration dates. Both patents would still end up being granted. Expiring on their original patent expiration dates. So just because there's no impact on term, it doesn't mean that an obvious double patenting problem doesn't still exist. And Dick, you were an examiner at the patent office for a while, and in fact, you were there prior to I think, an important change in practice, which has given rise to a lot of the recent cases related to double patenting. Maybe you could explain, sort of in the context of this slide, how that old practice used to be when you were there.
Yeah, for many years, predating my time with the patent office and afterwards, the concept was that if you had an ODP situation, what you would require is a terminal disclaimer in both applications, or if one was a patent, in the patent as well, such that they both were going to expire at the same time. Now, that was by practice in the patent office. It wasn't by rule. And somewhere along the line, and I'm not sure where, that concept has sort of gotten away from the patent office. And I think some of it has to do with the 20 years from filing. But today you can get into the unitary situation, which I think unfortunately gives the patentee a false sense of security with respect to ODP. Vince?
Yeah, that is a very good point. And it definitely is a situation that we now have to deal with. As we note here, that you may still have a double patenting problem. Double patenting is a judicially created doctrine. Terminal disclaimer is part of the statute, so is patent term. So as Dick mentioned, with double patenting, we're talking a judicial doctrine, and we're talking about internal office practice in terms of the requirements for disclaimers. Just because the patent office grants a patent, and just because they don't raise the double patenting rejection in the later granted case, doesn't mean that the double patenting problem still doesn't exist. And in fact, this unidirectional impact of the terminal disclaimer really became part of the issue when we look at the recent development of case law. In particular, we can look at the Gilead case, where back in 2014, the issue went before the Federal Circuit. And in this instance, two very similar disclosures that were not part of the same patent family were presented to the patent office. Were presented in litigation. And the contention was that by NATCO is that the 483 patent, which was later filed but earlier issued and ultimately had the longer patent term, whether that was invalid under obviously double patenting from a earlier filed and later issued but earlier expiring patent. The argument that Gilead made was that the focus should be on the fact that the 483 patent issued first, and therefore the 375 patent, which later issued, cannot extend the term of exclusivity of the 483 patent because the 375 would expire earlier. And the question that turned the interesting question that was turned here was that, that's really kind of looking at it the wrong way. We're not looking at whether the 375 grant would extend the 483, but rather with the fact that the 483, the later issuing and earlier expiring patent, whether that could qualify against the 483 patent. So in other words, did the 483 patent actually unjustly extend the patent term? And in the Gilead case, they said, yes, let's look at the monopoly extension. Like, is there in fact a monopoly extension? And that was looking at the expiration dates. Rather than looking at what was also argued, that we should look at the relative order of issue or the filing dates, none of that was relevant. What in Gilead found was that we look at the expiration dates of these patents to determine whether there's an extension, and that their order of filing or order of issuance doesn't matter. In fact, the primary focus in Gilead is that if we just look at in terms of the issue date for post-URAA patents, that would lead to the potential for significant gamesmanship during prosecution. And under the pre-URAA case law, where 17 years from patent grant was the controlling notion, it was very easy to look at dates of issuance because that was a sort of surrogate for the expiration or the order of expiration. And so it was a very simple tool for the courts to look at in terms of whether there was unjust extension by the grant of a later patent, like the Van Gorum case. But when we look at Gilead and we're looking at a post-URAA scenario, the problem with gamesmanship is that inventors could routinely orchestrate patent term extension by filing serial applications on obvious modifications of an invention, and they could just simply play with a priority claim of the applications. And as a result, you could effectively arrange for an application to be granted and have a later and later and later term. When there's financial incentive, people get creative. And that creativity is really what becomes the heart of the concern in a post-URAA world. And in fact, Federal Circuit was asked to look at that same year at AbbVie versus Kennedy. And what this case ultimately did was affirm that the doctrine of obviousness type double patenting applies where two patents that claim the same invention have different expiration dates. In Kennedy, they were very bothered that the result of the difference in the expiration dates led to a 6-year extension. I think it's important to look at what happened in Kennedy and why this case really echoes the very concerns with respect to gamesmanship that Judge Chen cautioned against in his holding in Gilead. In the Kennedy patents, we had an initial filing and it followed by a series of CIPs, a kind of ping pong back and forth between the U.S. and the PCT, and eventually what became the 766 patent was filed after about 4 years of intervening CIP filings. The second patent at issue is the 442 patent. And the 442 patent was filed as a continuation of the 766 patent. However, what became ultimately the chain that matured into the 442 patent, they did not claim priority all the way back through the CIP applications back to the original filing date of October of 1992, choosing instead to electively choose a shortened priority claim chain and only went back to the application at the end of the CIP chain, so as of August 1st of 1996. The result was that the 766 patent had a patent term that was measured from the October 8 of 1992, and so it was set to expire in 2012. Whereas the continuation application, the 442 patent, became measured from 1996. And so it was slated to expire in 2016. They had a 2-year patent term adjustment moving us out to 2018. And so the unjust extension that arose by Kennedy's practice is measured in that 6 years was that extension of the patent term based on only claiming a partial priority history. And the court decided that the 442 would be invalid without a terminal disclaimer over the 772 patent. So from the Gilead and AbbVie cases, the focus was on really the gamesmanship component. And the concerns of potential gamesmanship in the post-URAA world, and that there's an intentional decision or act by the applicant to file separate applications for overlapping or obvious subject matter, and that they claimed differing priority dates for their applications, whereas Gilead was not the same family. They were two separate families of applications. AbbVie was an example where they had a common ancestry. But in each instance, they were playing games with the priority dates, and the ultimate effect was they were seeking to achieve a staggered expiration date that pushed them later than what the statutory guarantee of 20 years would be. Now, in AbbVie, there was a patent term adjustment, but that wasn't a component of the analysis because the expiration date already existed. So what do we stand after Gilead and AbbVie? There was a couple significant questions that went unaddressed. The first is, what if the two patents are from the same family, and in fact, they have a continuity of priority. They go all the way back to the same effective filing date. The other issue that remains unaddressed is, can a later issuing earlier expiring patent qualify for double patenting if the reason for those different expiration dates is patent term adjustment? Well, in 2009, the Fallow case, arose out of the patent office and the Federal Circuit acknowledged that even post URA, there is potential for an unjust extension, and that there could be scenarios where even that unjust time-wise extension would arise from patent term adjustment or patent term extension. Now, the court didn't go through any details of what that unjust extension would be, but the Fallow decision and the decisions in AbbVie and Gilead were important because some commentators and even many litigants had argued that double patenting was effectively dead with URAA, that because we measure from the effective filing date, we don't have to worry about it anymore. Judge Moore wrote in Fallow that although that's the likelihoods or some of the problems and concerns were diminished, they didn't go away. There is still that potential, even under URAA, that just as we saw in the cases of Gilead and AbbVie, that there could be gamesmanship that extends unjustly the patent term, and double patenting remains very much alive. And in fact, even they expressly acknowledge that perhaps 154 and 156, the extension statutes, could also result in some kind of unjust extension of patent exclusivity, and that the old case law, even pre-URAA on ODP, still applies and still should be preserved. And that led us to really a case then that addresses sort of the questions that were teed up after Gilead and AbbVie, and that's the Magna case. Magna is the one exception to what I'd said earlier about pharmaceuticals being usually the industry that drives this. In fact, the only case that we'll talk about today that was not a pharmaceutical case is Magna. It maybe not surprising, being from Michigan. It was a automotive-related case dealing with high beam control mechanism. Now, the Magna Court was asked to look at the question really that was posed in the previous slide. What happens when we have a same family with continuity of priority dating to a common filing, so they both have the same effective U.S. filing date, but also the question of, can the later issuing but earlier expiring patent hold as a double patenting against the earlier granted and later expiring patent. And so the Magna Court, when this was decided in 2015, it was right on the heels of Gilead and AbbVie. And so not surprisingly, the decision focused extensively on the Gilead holding and said we have to look at the expiration dates, and cited many of the policy issues that would justify it, and said that Gilead would apply here. So the earlier filed patent would be invalid for obvious double patenting over the later filed, but patent due to a difference in their expiration dates. And so as a result, the 149 patent would be invalid without a terminal disclaimer over the 786 patent. And that was a loss of their patent term adjustment. Echoing the words of Gilead, the decision justified the outcome by emphasizing that permitting an earlier expiring patent to serve as a double patenting reference for a patent that's subject to the URAA guarantees a stable benchmark. It provides the public with a very useful tool, and so it's very simple to look at the analysis. And looking at the earliest expiration date of all patents that an inventor has on the same invention and its obvious variants would best fit and serve the purpose of the doctrine of double patenting. But is Magna good law? First of all, it's important to note Magna settled before the case went to the Federal Circuit, so we don't have the Federal Circuit's opinion on the matter. And in fact, subsequent to Magna, there are other cases that developed that call into question whether Magna got things right. And the first one is the Novartis v. Breckenridge case. In Breckenridge, another decision issued by Judge Chen, same judge who wrote the decision in Gilead. The scenario they look at here is where there is an earlier filed application that has patent term extension. And the subsequent case was a divisional of the parent, has the same common lineage tracing back to the same effective filing date. And that patent issued later, the second patent issued later, but it expires earlier. The scenario is very similar to what was in Gilead, but with a very important distinction. Now, the district court found that this was very similar to Gilead, and in fact, Gilead would apply, and Gilead would serve to invalidate the earlier filed but later expiring 772 patent on the grounds of obvious double patenting. But the Federal Circuit rejected that and said, no, Gilead does not control. Gilead and AbbVie as well were both patents that dealt with post-URAA statute. They both fell under the post-URAA standard of 20 years from earliest effective filing date. Whereas in Breckenridge, the cases straddled the boundary. One, the first patent was a pre-URAA patent, and the other one was a post-URAA patent. And so the Federal Circuit looked at this as being really an issue of a very narrow legal question, and that was, can a post-URAA patent that issues after and expires before a pre-URAA patent qualify as a double patenting reference against the pre-URAA patent? So as part of the analysis, the focus was on what really the objective of obvious double patenting is, and that was to prevent the patentee from manufacturing a time-wise extension of exclusivity through later expiring patents, and also to prevent the patent owner from controlling the public's right to use the invention beyond its statutorily allowed patent term. But the court, looking at these objectives and also looking at what Gilead and AbbVie scenarios were with the gamesmanship that was being played and playing games with the priority claims to stagger the ultimate resulting expiration. And none of that was present in Breckenridge. In fact, as they emphasized in the decision, whether this application was filed if both were filed as post-URAA patents, they would expire on the same day due to the common effective filing date. So you'd have a common benchmark for the 20-year calculation. And in fact, due to a terminal disclaimer, if they both were filed under the pre-AIA law, they would have expired on the same day as well. And so the only explanation that drove the change in expiration dates wasn't gamesmanship by the patentee, but it was the change in the patent laws. And the Federal Circuit held that a change in patent term law should not truncate the term that was statutorily assigned to the pre-URAA patent, and that to require patent holders to truncate any portion of a statutorily assigned term of the pre-URAA patent that would extend beyond the term of the post-URAA patent would be entirely inconsistent with the URAA transition statute. On the same day, Judge Chen wrote a second decision, and that was in Novartis versus Ezra. Again, a similar scheme that we've seen time and again can be played out. We have a initial patent. There's a second that files, but in this case, they have similar disclosures, but there's no common lineage. They don't there's no continuation or divisional claim from one family to the other. But in this instance, unlike the case in Breckenridge, the setup in this case, both patents are the actual URAA status isn't going to play into the ultimate decision. The issue here really is whether or not the patent term extension would be an unjust extension. So it's looking in Ezra the interplay between patent term extension and obviousness double patenting. I think an interesting question that comes to my mind in looking at the actual fact pattern here is both the 229 and the 565 patent could qualify for patent term extension. But Novartis actually chose the earlier expiring patent to extend, which actually pushed the date beyond the 565 expiration date. And so I just want to ask Dick real quick if you can comment on just sort of the selection of which patent to extend and how that works.
Well, I think what you do when you're looking at this is you're looking at what is the subject matter of each of the patents and which is the one that's going to get the longest PTE. Here it looks like the 229 was going to get the longest PTE because of the way that's calculated, since clinical trials were probably begun before the filing or at about the time of the filing in 1993, which is why they get 5 years of PTE. Second, you're also looking at the claims, because when a generic files its ANDA, it can exclude, under the skinny label, any patented indication. So if the 565 patent was adding a new indication, that could be excluded. And on 2014, when the 229 patent naturally expired, you could go ahead and have your ANDA granted and begin the generic competition, and the 565 patent would have no effect since the label of the generic would not have the patented indication. And the other consideration is which of the patents actually was the stronger from the viewpoint of validity.
Excellent, excellent points and very important things to consider when choosing which one to look to extend. In this case, the court held that they held that the double patenting does not invalidate a validly obtained patent term extension where the patent is earlier filed and earlier issued and has ultimately a later expiration date, where that extension is due to the statutorily allowed patent term extension. This distinguished from Gilead because the concerns that were posed in Gilead for gamesmanship were not present. The patent term extension is really a question of a statutory question. Its calculation is based squarely within the statute, and the gamesmanship component doesn't play a part in that. In fact, the court looked back and said this is a logical extension of their holding in Merck v. Hitech, where they said terminally disclaimed patent could still have its term extended with patent term extension, and that Congress doesn't limit the availability of patent term extension to a specific patent. The patent owner is allowed to choose freely between which ones to extend. There's no such thing as an effective or de facto patent term extension, even if the patent that you choose to extend, as in Ezra, has ultimately a later expiration date than the second patent. You're not a de facto extension of rights under the earlier expiring patent, and it also is not inconsistent with the double patenting policy objectives. And so when we put Ezra and Merck together, what we can now see is pretty clear when we talk about the impact of terminal disclaimers and the interplay with patent term adjustment and patent term extension. If we look at a scenario where we have a patent B that has patent term extension is slated to expire later, and a terminal disclaimer is filed over patent A, you lose the term back to the expiration of A, but we still get that patent term extension. You just slide the base date for the 2-year or the 2-year window base date just moves over to the expiration of A. And it wouldn't matter even if we added in patent term adjustment on patent A, it's the same impact. The disclaimer just shifts the focus and the calculation over to the end of the expiration, the full statutory extension accounting for PTA of patent A. But can we do better than Ezra? And the answer, I think, is yes. I think we can. And I think we saw that earlier this year in Mitsubishi Tanabe v. Sandoz. In Mitsubishi Tanabe, there was an initial patent that had 1,079 days of patent term adjustment. A second patent, the 219, was filed as a divisional off of the same family. And this looks an awful lot like the scenario that was addressed by the Western District of Michigan in Magna. So the issue that was posed by the New Jersey District Court was whether a later issued patent that expires before the earlier issued patent due to a statutorily allowed term extension under 154 can act as a double patenting reference. Now, I think it's important to note that this is very different from the situation in Gilead. Right? Again, the issue is one of gamesmanship in Gilead. Really, Gilead and AbbVie looking at the way that the priority claims were driven to maximize patent term and unjustly extend the patent life cycle. But in patent term adjustment, is as the New Jersey District Court said, is that there's not the same potential for gamesmanship by the inventors. Right? By definition, patent term adjustment is a reward for delays caused by the patent office. That's not a patentee fault. It's not a patentee game. That's a statutory scheme. And so the district court held that the claims in an MTP are not invalid under the obviousness double patenting, where we're looking at the same family and the patent term adjustment is what drives the later expiration date. But that's directly at odds with the holding in Magna. Now, they recognized the Magna decision. They recognized that Judge Wilson recognized that, yes, in fact, he's coming to a different conclusion than Magna. But his rationale was, yeah, but Magna, all they had to rely upon was Gilead and AbbVie. And they were really a case of first impression. And in fact, since this case never went up to the Federal Circuit, the Magna decision, now the New Jersey case is really a case of first impression, and said Magna doesn't apply. He's not bound by Magna anyway. It's another district court. But looking at Magna, he says, Judge Wolfson says that they're all pre-Ezra. Ezra changed the game. Ezra looked at really the whether a judge-made doctrine like double patenting should be allowed to cut off the statutorily authorized time extension. Even though Ezra dealt with patent term extension, they're both patent term adjustment under 154 and patent term extension under 156. They're both subject, they're statutory constructs. And so relying heavily on Ezra, Judge Wolfson declined to permit a judge-made doctrine to cut off the statutorily authorized extension. And of course, this case was appealed, and we in the patent community were kind of excited to see that how this was going to resolve. There is a direct conflict, and unfortunately or fortunately, November 9th, just last week, an order remanding Mitsubishi Tanabe was entered because parties had settled. And so, Dick, this is two cases that the rug was ripped out from under us on the same issue. And so, having worked through a lot of litigation cases yourself, can you give us some insight of why maybe in this unique situation, pharmaceutical cases, a lot on the line, why would Magna and Mitsubishi Tanabe settle?
I think this is pure speculation that you were looking at. By settling, Mitsubishi Tanabe was securing a judgment which was going to keep the generics off the market. Most likely what Mitsubishi Tanabe gave up was a little bit of the patent term adjustment at the end. And for Magna, challenge for the winner was that the decision really, they had to be concerned that it might not stand up on appeal. And so by settling, they simply guaranteed that they were going to get to go to market earlier than they would if the patent was valid. And in Mitsubishi Tanabe, they were going to recoup, keep their monopoly for longer than the normal expiration of the patent. They just had to give up a little at the end.
Well, thank you. And it's interesting, but now we are left with Magna and Mitsubishi Tanabe standing in direct opposition to each other. The Federal Circuit has not considered this question, the specific question with ODP, where the ultimate issue of the difference in expiration dates is driven by patent term adjustment. So it's left for us to polish up our crystal ball and kind of speculate where we think this would go. And it's our opinion that the outcome in Mitsubishi Tanabe would be affirmed and is proper. It is most consistent with Federal Circuit's decisions in Breckenridge and Ezra, and in fact, it doesn't, I don't think, run contrary to the outcomes in Gilead or AbbVie. And in fact, the overriding point that Ezra was making is that we shouldn't allow a judge-made doctrine to cut off these statutorily authorized time extensions. And that should apply whether it's PTE or PTA, both guaranteed under the same patent code. And so, in fact, I don't believe that a later filed, later issued patent that expires before the earlier filed, earlier issued patent should be available. In fact, it should not be available for double patenting where it is a statutory term extension. But what if we changed slightly the fact pattern in Mitsubishi Tanabe? And in this instance, let's say the later granted patent is going to issue with a patent term adjustment, making it expire later. Now, I think it's important to note in this instance that the 219 is a divisional of a divisional. And in fact, if they're true divisional applications, the patentee would be able to avail itself of the safe harbor provisions under Section 121 and avoid the double patenting rejection. And so they would be entitled to the two patents with the different dates. Now, in Mitsubishi Tanabe, there were other patents involved in the case. Not all of them were divisionals. One, in fact, was a continuation. And in fact, 121 was one of the teed up issues in Mitsubishi Tanabe, but the court punted on it, didn't have to reach that decision of whether 121 actually applied under the circumstances of that case. So what if we did change one of those divisionals to a continuation? Let's say, and so now we can't avail ourselves to the protections under Section 121. Dick, how do you think this might play into it? What do you think the outcome might be after seeing these cases?
Well, I think the analysis that you would make would be the same that the Federal Circuit did under Gilead. And the question was there a game played by the patentee that resulted in the later expiration of the 219? And here again, what has happened is the patentee didn't do anything wrong. The way the patentee filed, both patents would have expired on the same date, but with the ineptitude of the patent office in prosecuting the second filed case. And so I think it would be very difficult for a court to justify cutting off a statutorily authorized extension with the judge-made double patenting provisions, especially where it was, again, an agency problem, not a game played by the patentee. So I think the result would be the same. Obviously, if you've got the safe harbor provision, that's belt and suspenders, which you don't have with this one. But I think it'd be a closer case than the Mitsubishi Tanabe, but I think it should come out the same way.
I agree. I definitely think Ezra said it quite well. I think the framework, the analysis there, and is important, as well as the lack of the gamesmanship concerns that Gilead and AbbVie were so focused on. So where we stand, though, is that Ezra and Merck suggest that in the PTE context that statutory extension overrides the obviousness double patenting. And the courts haven't chimed in, but on patent term adjustment per se, I mean, the Federal Circuit hasn't come down with any decision. But we do have to recognize that the Fallow decision has opened the door for the possibility that patent term adjustment may be adversely impacted, that there may be unjust a time-wise extension. What's not clear is what was intended there, and whether a decision on a overriding ODP question where, say, they're not even part of the same family, but the patent term adjustment is the result, giving rise to the difference in expiration dates. We're not sure, and I think it's unclear. But I think when we look at the focus, just like Dick mentioned, when we look at the focus of Gilead and AbbVie at the potential for gamesmanship and staging to arrive at a later expiration date, where you have a statutory guarantee, as in 154, and that statutory guarantee is what gives rise to the later expiration date. There's a good argument that could be made that just like in Ezra, that those the term should be allowed to stand, and double patenting should apply. And so I think what this leaves us with some take-home advice is first, be wary of double patenting rejections. It's definitely a trap. Be careful when you look to assert your patents. Double patenting still may exist even if the patent office didn't raise it. Keep in mind that a terminal disclaimer is an expedient tool for making double patenting go away, but it also cuts off not just term but patent term adjustment that would extend beyond the expiration of the patent you disclaim against. So a careful analysis has to be made as to whether the disclaimer is appropriate and whether you could live with that disclaimed term, as well as the joint ownership aspect. A policy that just in areas of like pharmaceuticals, medical devices, things that have regulatory review components, long lifespans in the life sciences, you have to be very cautious of just adopting a policy that says we file terminal disclaimers. You want to carefully evaluate rejections, look at the merits of the rejection to see if you could actually successfully argue that it is not an obvious variant. There's definitely differences justifying two patents existing. Where there is a already granted patent, you have to be mindful of how prosecution and whether it's a disclaimer or double patenting in a pending child application, you have to be mindful of what impact you may have on the parent application in terms of arguments or terminal disclaimers. It's always best to delay the filing of your terminal disclaimer until prosecution on the merits is over. You want to get an indication of what the allowable scope of subject matter is in your second case, because you certainly can see, and many times it does play out, that during the course of prosecution, the claims are often amended. And some of those times it's after you think you've resolved all issues and you've put in a terminal disclaimer. Problem is you can't expunge and redact that disclaimer, and so you want to make sure that when you ultimately file it, that the obviousness double patenting is actually still a valid rejection, not something that was rendered moot by the course of the proceedings in either the parent or the child case. Where you have co-pending applications, even though patent term adjustment isn't officially calculated by the patent office until the patent is going to grant, certainly the calculations should be readily available and accessible by any patent professional and should be very capable of doing so. I think it's important to take a look at your co-pending applications. Maybe do a back of the envelope calculation of what you think the PTA might be, and then consolidate claims in the application that has the longest PTA if possible. And then take a careful look at that child application, the one that might have a shorter PTA, or even if they're not same family, if the second case is going to have a shorter life cycle, you may want to abandon that case after consolidating claims into the case that would expire later, just to avoid double patenting problems. And of course, you file a terminal disclaimer as a last resort. But again, be wary, because that may set a trap on your parent application to consolidate the claims into. And I think one last question I want to pose to Dick is just returning to this issue of sort of our hypothetical that we posed based on Tanabe, where we talked about the safe harbor under 121 and the divisional and the difference between that and the continuations. Can you just make maybe a couple of comments about sort of the importance of that and whether we call something a divisional or a continuation, and why, what we need to do to basically avail ourselves to 121?
Well, the case law is pretty clear. If this is a restriction and you file a divisional that is consonant with the restriction requirement, then you're going to be safe harbored. The problem is that sometimes people get sloppy, and when they file what should be called a division, they call it a continuation. Once you do that, you cut off your rights to safe harbor. Now, it may be that I believe may be the reason that the court in Mitsubishi Tanabe did not consider the safe harbor provision of 121, because there was a continuation in that chain. And that might very well have set up a double patenting situation, which would have been a messy one for the court to deal with, where it was easier to talk about the statutory the PTA being a statutory extension, which should trump the judge-made ODP. So when you get when you're told to file a continuation, make sure that it is truly a continuation and not in response to a restriction requirement.
Well, thanks, Dick, and I certainly want to thank all of you for joining us today. That concludes our presentation. We're happy to answer questions. And if you don't want to pose them now, but you think of them later, our email address is here, and the slides will be circulated to all registrants. And so we thank you for your time. I'm not sure if any questions are present. If there is, we'll answer them. If not, that will conclude the talk. But I'm not seeing any questions. So
No questions.
With that, I thank everyone very much for your time and your attention today. Please have a very safe and wonderful rest of your day and weekend. And look forward to talking to you more directly and personally. Take care and bye-bye.
Bye-bye.